at the moment, the court's understanding of the criteria for the grant of interim relief are in a state of flux. Traditionally, the position was, and to a great extent remains, that an applicant for interim relief had to show, firstly, that they had a winnable case, described usually as an arguable case, and secondly, that if interim relief was not granted, they would be likely to suffer serious and irreparable damage before judgment could be delivered, unless, of course, the status quo was maintained. There were two developments that put that understanding under some strain. The first development occurred actually quite a long time ago, in two cases, one decided in 1980 and one in 1990, the Commission against France and the Factortame case. Now, this development was a shift in emphasis from the use of interim relief to protect subjective rights into the use of interim relief to preserve the effectiveness of the court's judgment in the action. But it took a surprisingly long time for that development to trickle through into the court's case law. There were some fleeting signs of this happening before 2015, but the real breakthrough occurred in that year when the second development occurred, and this was the Van Breda case. Van Breda was a public procurement case in which the European Court discovered that its traditional approach to the grant of interim relief was actually incompatible with the EU public procurement legislation. That legislation was directed at what member states did in their own jurisdictions in regard to public procurement, and so far as interim relief is concerned, it concerned the approach of national courts. But in Van Breda, the European Court found it awkward to apply its own traditional approach and therefore do something that was different from what national courts were required to do in the case of public procurement litigation. And therefore, it modified the traditional approach. The position that we've now reached is that it is unclear to what extent this flexibility that you can have in the traditional criteria for the grant of interim relief, to what extent it applies in other cases. And here the case law is uncertain, because in some cases we're told that there is only one exception to the standard criteria for the grant of interim relief, and that's public procurement. In other cases, we're told that there are two exceptions, called systemic impeding of effective judicial protection and cases of flagrant and serious. And in other cases, again, we're told that there are three exceptions: public procurement, sanctions cases, and certain cases involving documents. The result is that anybody who is thinking of applying for interim relief needs to start off with the standard, the traditional criteria. But they also need to look very, very carefully at these anomalous cases to see the extent to which they can flex the criteria for the grant of relief and justify taking a different approach, which may be more suitable to the needs of their